Hello, my name is Richard Cunningham. I'm an attorney with Cunningham Law. I practice in asset protection, business, estate planning. I have my master's of law in tax, so I do a little bit of tax, but I don't do any tax returns. So a little bit about me. I've been attorney for 26 years. I started from Seattle, Washington, and I've been down here in Nevada for 21 years now. This year is 21 years. I work on asset protection plans, helping businesses structure and shielding their wealth as much as possible. Most of the time I add that in with some estate planning. And what we're going to talk about is a general asset protection. I'm going to say some things that have nothing to do with me. So I'm going to talk about another industry because there's a step and we want to layer those to be able to have the best asset protection possible. So why asset protection matters? Your wealth is exposed when you don't. If you just have a revocable trust and you put all your assets in there, and let's say you have a trust that has 10 real estate properties, you have now exposed not only those other properties to claims, but your whole assets. So your brokerage account that's in there, your checking account that's in there. So you want to make sure you protect your wealth so you don't have those problems. A lot of times we want to try to do 2 or 3 layers of defense. For real property, insurance is the number one. Insurance is incredible. I view it as sort of prepaid legal. They don't want to leave, they don't want their money to go anywhere. So they are really tight and make it difficult. They have to be careful that they don't do what's called bad faith claims, but most of them know what they're doing and they will protect you, and that's the first layer of defense. Then we look at LLCs and some revocable trusts or other types of trusts to determine what the next things we can do. But the most important thing is you need a plan before something bad happens. Once something bad happens, it's very likely that the court will undo those actions. It's something called, in Nevada, it's called a fraudulent conveyance. In other states, it's called avoidable transfer. It's not fraud like criminal fraud. It just is that what happens is the court says, hey, those transfers you made aren't valid, they're void. And so they come back in so creditors can reach those. So what risks do landlords face? The most obvious we all think about is premise liability, right? Someone slips and falls, something happens to there, dog bites, things like that. Then we could look beyond the property, a wrongful eviction, all those types of things that can happen if you aren't, one, following the law correctly and have good professionals. And just because things can happen, and that's why you have homeowners insurance. But the most important thing is, if you don't structure it correctly, one suit on one property can expose all the other properties. So someone slips and falls and dies on one property, granted you rented it out and the tenant's supposed to be liable, you're the owner. And if it's a latent defect that you knew or should have known and you didn't correct, they're going to come after you too. And if your insurance isn't enough, then you individually are if you own the property individually. So this says the same thing. What's at stake without a plan? Your personal assets. That one claim can affect your whole portfolio. And when you have everything sort of available, you aren't in a good negotiating point when you're talking to creditors. Because they're like, I can attach all this. Why do I need to negotiate with you? So what a layered plan does, it gets a little bit more shield, and it makes little stages to protect your assets. Usually you try to have your one property can be isolated, or 1 or 2 properties are isolated. So you are managing your risk. And then it gives you a little bit easier to settle the lawsuits, because if you only have 1 or 2 properties there and they don't pierce the veil, which I'll talk about a little bit later, that will, that protects you and puts you in a better space. So when you talk to creditors, you're going to like, well, it's fine. These are the 2 properties, or this is the property. And then they're looking at insurance and other things we're going to talk about in just a few seconds. So this is a hypothetical story. So let's say a tenant won a $500,000 injury claim against the landlord. So their insurance was only $300,000. So the insurance company pays out the $300,000, but there's still a $200,000 difference. if they filed the suit, because if they hadn't settled with the insurance, they now have a lawsuit for the $500,000. Insurance pays that $300,000, so the judgment gets down, but there's still $200,000 that you have to pay because you own the property individually and you didn't put any other things in place. So what happens? That gap is you now have to pay for. Same thing for cars, personal injury. If Nevada has $25,000 is the minimum that you have for protection. I can tell you that your bumper having problems, it's going to cost a lot more. So regular insurance, your regular home insurance. Then you have umbrella coverage. So depending upon what there is. So sometimes you can still have a personal umbrella policy if you have maybe 1 or 2 properties and they don't feel like you're technically in the business. They sometimes will allow that LLC or that property to be covered under the personal aspect. But usually when they find out that you're renting, right? So you don't, it's not your personal residence. A lot of times they make you get a commercial umbrella policy. And what umbrella policies do is they cover the gap. But what you have to have, and what most people don't realize, is you have to have the highest amount of insurance. So I'm going to do cars because it's easier for everyone to understand. Umbrella policy, you have to have a $250,000, not 25, not 100, not 150, 250.
Max.
The max. And then they'll cover anything above that max. So, and usually it's the person who has the policy already, they usually offer the umbrella policy, so it's the same company that does it, maybe a different policy, so you don't have problems with different defense counsel. But some people shop, so they have an umbrella policy here, they have a regular policy here. Umbrella policy doesn't kick in until the regular policy is, it's a little bit of a step, but it's the best insurance policy because umbrella policies can be as long as much as 1 million, sometimes up to 5 million. Insurance companies do not want to give anyone $1 million. So they have really good defense attorneys, and so that really helps you. And the likelihood is you're not going to have much more above that. And they aren't that expensive. So that is a great way. Now the next level.
If you're my attorney and we're working on this project together, the planning, which is what you're advocating here, is that we plan ahead.
Yes.
You would help me figure out what I should get or not get, and you would say like,
I think we would bring your insurance agent into the picture, and we would work as a team to determine, because there's price, it's your budget, the likelihood, right? And maybe you do some of this, maybe it's only $1 million policy, but then we would look at some of these other things that we could do as well.
But
Right.
correct me if I'm wrong, I had this discussion.
But I have to say this, I forgot to say at the beginning, it'll be at the end. This is only for informational purposes. There's no attorney-client relationship. So I'm not getting any legal advice, and no one can rely on what I'm saying for legal purposes for your specific case. Yeah, and there's only so much you can do. So what happens is most people don't want me to be on the phone with their life insurance agent because they don't want to pay me my hourly rate. So what I suggest is you talk to them, and maybe I talk to them for 15 minutes after you start the questions.
Yeah.
But the thing is ideally you'd want your insurance agent, your CPA, and your lawyer to work together. The difference for me is I do trusts and I do wills, but I also do LLCs and business. And a lot of my clients are business owners, and I also do their estate plan, so I can sort of recognize them both. But so it's one less professional. But those are the things that you have to do. And to be honest, I'm not a litigator, so I would always bring a business litigator if there was actually a lawsuit. I can help plan and do things, but if you're going to ask me to tell you what the rules of evidence are after 26 years, I'm not going to be able to tell you.
But you have a guy that can.
I do have a guy who can. You should have one property and one LLC. The problem that I have is that we also have to be realistic, and you have to be cost effective. So you need to look and do a cost benefit analysis and the risk that you're willing to take, and each one has a different risk level. But then we look and see what's the most advantageous. I have clients who start off because they have 2 or 3 buildings, and we do it okay, it's separate. but then they buy another one and they're starting to say, I don't want to have another LLC. I'm tired of paying all this money every year. And then we say, well, okay, let's look. Is there one building that you feel like we could sort of mix with and have some synergy? That's what you try to do. But again, if you ask me what's the best way for protection, I would say you have every entity have one property, and that entity should also have more than one owner. And the reason why I say more than one owner is because once it becomes a partnership, or it should never be an S corp. This is my tax person. This is my pet peeve. If you have an LLC that's taxed as an S corporation, should never own property, because moving property out of that LLC is a taxable event. Where if it's a partnership or a single member LLC, you can move in and out of the different partnerships and not have a taxable event. So that's unless there's other rules for partnerships.
That's a good tip.
Yeah. So the general rule is that if someone sues the LLC, they have to pierce that corporate veil before they can get to the members. And LLCs are limited liability companies, which means that members have a limited liability. If there's only one member, then it's easier, not to say that it doesn't happen all the time, it's easier for someone who's suing the LLC to say, this is really an alter ego of this owner, and there's not really limited liability. And so you have to go through, and what it is they have to pierce the veil. With brand new people, is what I see the most is they create this LLC, the money's in there, they get some rent, oh, I need to pay my rent, my mortgage on my house, and they use that money directly into there. You're right? Oh, I need some groceries, I have the LLC debit card, let me just do that. What you've done in that case is you and the LLC are one, and they can argue. Now, accountants sometimes say, hey, we'll just record it in the books and it doesn't make the difference. But if you're sued, they're going to say that money went directly into there and it was not a business purpose. And so this is not really a business entity, and we can now go after you individually. So I always tell people, and I'm not popular when I say this, is with LLCs and rentals, what you should do is treat it like a business, right? You determine you need a reserve. Keep a reserve in there, or build up a reserve before you make distributions to yourself. Do distributions maybe not every month, maybe you do it every couple of months or on a quarterly basis. Again, it's showing that you have enough money in there, because if you take all the money out every month and then you get sued, there's no money there. Yes, you have insurance policies, but there's no money. So it's always good to have a reserve, because you're giving someone something to go after instead of going after everything. Now, in litigation, they're going to sue the LLC and they're going to sue the members. It's just what they do. But it doesn't mean that it works. They have to show there's a piercing. When there's more than one member, there's a partnership. And so you're now affecting someone else who may have nothing to do with the person you're suing.
So it's easier to defend.
It's easier to defend. It's harder to pierce.
And
it also makes it...
Like, it probably shouldn't be like a married couple, then it should be like
married couple
else,
can be, because what you would do is you would make an agreement that it's each of your separate property. We don't make a community property.
Okay.
And then you both have an interest in that. Do I recommend that? There's a whole other reasons why I would say no, but that is sometimes something that happens.
Interesting.
Yes.
Well, then what am I supposed to do? I'm a single member LLC
That's
all
fine.
the way down, because there's nobody else.
But we just want-
I don't know who else to involve.
Couldn't you appoint like a treasurer or somebody that has a minor role in the LLC?
Well, you can have other officers if you another member with you, but really right now you have those layers. But as long as you don't make it so that you're going to try to follow, and so they're going to have to try to prove that it's really an alter ego aspect. The biggest risk for the piercing is what's called the reverse piercing. Is I'm suing you individually and you have all these homes in different LLCs. I want to get to those LLCs. So I have to now do what's called a reverse pierce analysis and say, you and these LLCs are alter egos, so you don't have the protection of the LLC, and I can now go down there and get them. Now, that's hard because under Nevada law, this is what everyone talks about when you have an LLC. There's something called a charging order. So if I sue Michael, and I have a judgment against him, he owes me $100,000, and he has 3 LLCs that have different properties. I want to get to those LLCs. So I try to do an action. Well, really what happens is this is called, my only remedy is a charging order, which means that I can receive any distributions that he would otherwise be entitled to until my judgment's been satisfied. So if it's not that satisfying, right? And if I get those distributions, I may also have to pay the taxes on them because it's being distributed to me. So sometimes you make it even more complicated for them if you wanted to. It's not as easy as it is. But he now has leverage over me, right? Because I can't get to those properties, but I want to get paid.
Negotiate. Work with us.
Now, he did not set these up to hinder or defraud or delay creditors, which is those fraudulent conveyance rules. He just did that because it makes sense and he's a professional and he knows everyone's supposed to do that. So that makes it, and it was old and cold. He did that a long time ago before I even sued him, right? He didn't even know I was a creditor. So there are factors that help on those. But if you have multiple ones, you have multiple layers, you may want to start thinking about maybe you need to have, there's different things that you would need to talk about and address at that time. It's not really set for this introductory kind of talk. But yes.
With a charging order,
Yeah.
where does a lien order come in, or at all?
So what happens is I get a judgment, and I have a judgment against you. And so the only way I have to execute on it. But the only way I can execute on those LLCs is I get a charging order. So I step into your shoes and I get whatever distributions you're entitled to.
Okay.
Well, if you've never made any distributions, or maybe, hey, I'm not going to make any distributions anymore. But that gets sued because you're not acting in good faith. But there are things that make that more difficult. And so most creditors don't want to be dealing with that. But I cannot put a lien on the house. I can put a lien on all your property and the real property records that you individually have, and I now have a lien against those LLCs, but it's not on the property.
Okay.
Right? So, it gets a little more complicated. I am giving broad legal strokes. Everything is different, and it's more specific. But that's why everyone does LLCs, is for the charging order. Nevada has a really strong charging order aspect because we basically want to be a credit asset protection state. We have Nevada Asset Protection Trust, which I'll be talking about in just a second. But those are the things that kind of, we want to be viewed as like the Delaware of the West. And so it helps. We have a business court. We have other things that are a little bit different. So it's not just usually just a regular civil case. If it ends up becoming a business dispute. The biggest thing that's happening right now for individuals and people who have rentals that are residential rentals is that insurance companies are looking at roofs more. And sometimes if it's over 20 years old, some of them are not accepting they'll say, well, we're not accepting you unless you get talk to a roofer and they do an analysis or whatever. So that also will have an effect. Umbrella insurance that we were talking about fills gaps. So it sits above your policy. So once your policy is reached, your regular policy, it then kicks in on certain things. So fraud, bad faith, all those bad things, it's not going to cover. But it's liability usually that it covers. So again, I'm going to give a car example just because it's easier to explain. I have a $250,000 car aspect. I get into a big car wreck, it's my fault, someone dies on it, then it may end up going up for negligence, things like that, may end up going higher, and so sometimes you want to have that extra layer. So, but there is a cap in Nevada, so it necessarily doesn't go up that high, but that gives you that extra protection. But it's really good for landlords, because if you have that commercial one, then it usually will cover your additional liability to cover that gap from what your $300,000 is. It could give you that extra amount. Now, maybe that extra amount is only $200,000, like I had that example, but that's still $200,000 you don't have to pay, and you maybe only have to pay, $200 a year for that. I would pay $200 a year to not pay $200,000.
Yeah, it's not
Piece of
much
mind.
to add an
Right,
umbrella policy. We have one. It's like nothing.
So LLCs are that separate shield, like we were talking about. It walls off your business from your personal. Now, this is a pet peeve I have, so I'm going to talk about it. A lot of people put their personal residence into the LLC, and it's not, one of the things you can contest is this is not a valid business purpose.
Right.
It's yours, so if you do that, make sure you have a lease, and make sure you're paying rent, and it should be fair market value rent. Now, if it's a LLC that works like it's yours, wholly owned by you, for tax purposes, it's like taking money from one pocket to the other, so there won't be a taxable event. But for state law purposes, you have an LLC is a separate entity in Nevada law. It's not you, and we're trying to take advantage of that. But most of the time, people have an LLC, they have their house in it, and they're saying, okay, it's a disregarded entity, so I can still take my mortgage deduction, so I'm acting like it's totally mine. And that's not going to necessarily give you the protection, because the first thing they're going to say is, this is no business purpose, why are we giving it business protection? So we talked about the charging order protection. That means if you get sued, the only way that I can get something from you is I put a lien on those distributions, so I'm able to get those distributions and only those distributions. There is litigation later on if you're the manager and you don't make distributions and maybe you're not acting in good faith. Those are different matters to talk about later. But in general, when people see a charging order, they're like, damn, I'm not getting to that underlying aspect unless I can do that reverse pierce. And that's the thing, is why you treat it like a business. You have a reserve in there. You're not having to pay your mortgage. You're not having to pay for your groceries. Now, when I started my own firm and it's off on my own, I know what I'm not supposed to do, but sometimes you do it because you're brand new. You're starting off. The idea is to stop that as soon as possible. So I always put it into my checking account and then used it. So I learned that. But I'm a business owner. Sometimes it's like, can't I just write the check and I'll reimburse it? And I'm like, no. I mean, warning signs. But it's easy to do, and so you have to be vigilant about it. So a multi-member, again, I explained, is stronger. It's now more than one person. So if I'm suing Michael, and
stop saying that.
if I'm suing Catherine, and she's in a LLC with the three, with all of us in here, then the court's less likely to say I can pierce that because I'm affecting 5 other people. So that it makes it easier to protect.
Wow.
There's case law in different states and bankruptcy courts that they have allowed that reverse pierce of the LLC to have the creditors be able to get to those underlying assets because they viewed it as an alter ego. A lot of times
there's probably fraud involved.
Well, fraud, bad faith, all these other things that they didn't follow it right. So, but that's what it is. Now I'm going to talk about series LLCs. We talked about that a little bit before our meeting, and let me explain what they are, and then I can talk about the plus and benefits. Series LLCs in Nevada, we can set up a series LLC. You can form it with the Nevada Secretary of State. It's one filing. It's only one annual list you have to file, and what you do is there's a place that you have to say, this is a series LLC, and then you can create more than one series underneath that LLC. So you could have a series holding Building A, series holding Building B. You can have different members in those series.
Oh my.
And the issue in the law is you have to have separate books and records, including you have to have different bank accounts. You can't merge things together. Otherwise, you don't have the asset protection. So under Nevada law, if you have a certain language set forth in the statute, that the statute says you have to have certain languages in your articles of incorporation.
These are relatively new, aren't they? Decade old, maybe?
Yeah, I guess it depends. You and I, yes, it's relatively new. For some people, it's super old.
It's a slight.
For my 19-year-old, that's old, Dad.
Yeah,
right?
yeah. Well, let me ask you a question though. I'm a little shy about these because do they have a lot of case history of being successful?
So
Or do you know?
most people, it doesn't really happen, but the problem is there's some logistic problems. Some banks won't accept them.
Oh, I see.
And if, let's say that Michael and I are members of one series, and he and Catherine have an opportunity to say, hey, let's buy this house in California. and let's put it into a new series. So we do that. But in order to do business in California, I have to register the entire entity. And California doesn't recognize series LLCs. So if someone gets hurt or something happens with that property, in California, that property owns all these other ones, and they're not going to necessarily respect. Now, there are arguments that someone said they will because it's the full faith and credit, but you have availed yourself of something that's Nevada specific to a state that doesn't recognize them and put the whole entity into the jurisdiction of California. So there hasn't been cases on that, but yet. I'm sure there will be, or they get settled because no one really wants to have that happen. And then you also have to have a separate tax identification number for each series. So you're still paying the same cost for taxes. You have to have different bank accounts, so you're still paying the bank fees. The only difference is you aren't paying that annual fee to Nevada, the 400 and whatever, plus the registered agent. So you are saving money if you have 10 entities, but the problem is no one keeps the books and records together. And if someone really doesn't understand a series LLC, I had someone who recommended, hey, let's just have this whole series hold all the money. You just blew that. You blew it because now there's no separate books and records. The bank accounts are there. There are ways we can do something else, and I'm not necessarily going to tell anyone right now.
So the plaintiff attorney finds that by subpoenaing the bank records.
Well, if I'm suing someone, it says, if the house, there's also some issues with the recorder because the recorder sometimes doesn't understand it. But let's just say that we have ABC LLC and we have Series 1. And so it says ABC LLC Series 1, a Nevada Series LLC. So I go look and see, oh, there's ABC LLC. If I'm suing whoever has ABC LLC or the property there, first thing I'm going to ask for is all the other LLCs.
Right.
And I want to see all the bank records to make sure that they're separate.
Yeah,
all those things.
LLC number 18, like, there's 7. It's a party. There's 17 before it.
Right. So those are the risks of series LLCs. Some people swear by them. I will do them if I know, one, they have a really good accountant and they know they're going to follow the rules. But people tend to go into habits and do the path of least resistance. Well, what's path of least resistance? I'm going to open one bank account and I'm going to allocate it so I have a pool fund. That's not allowed for series LLCs.
Right.
So they're there. They are a good aspect, but if you look at a lot of developers, they don't have them. They want the separate, distinct for each project. So I say try to find, they're the ones who know the best about asset protection because they build all these things, right? So those are one of the things that you kind of look at to see whether you want to do it or not. But they are there, and they may be of help in certain circumstances. So, if Catherine had a client who says, I want to buy 10 properties here in Las Vegas, we may want to do that. But again, if they say, but we're going to branch out to Arizona, they're not going to remember me telling them don't do that when they do it. And so that's when you start having those issues. So there's a lot of risk with them if they're properly managed and they're great for the right person, but they have to be on top of it, and even more so. So what I see a lot of times is that those separateness is not done. I had a client say, well, I'm just putting it all up in the major LLC. It's holding all the assets, all the cash. There may be a way to do that. I probably wouldn't do that. I would set up another LLC and do some other things that you try to protect. But when you start going down that road, you better be a licensed real estate agent if you're leasing and managing and doing all those other things, right? Because if you're a separate entity, and if each of these series are deemed to be separate entities, if one's managing for the other, they're not the owner. So you go into the whole issue of whether you're licensed or not to be able to do it. So if you have one LLC and I'm managing it, I don't have to be licensed because I'm the owner. If I have a series LLC and I have 2 properties and I'm managing the second property, but maybe I'm not a member of that second series. Maybe it's someone else, and I was, but I sold it out because I didn't want it anymore, but we kept the series. That causes some issues down the road. So let's talk about trusts. Nevada there are a few states in the US now that have domestic asset protection trusts. Alaska and Nevada were the first. South Dakota has one, which is really good. And if you talk to several people, South Dakota and Nevada have really, are almost comparable. The one thing that Nevada has is there's no exception for creditors. So in Washington State or in other states, if I'm a creditor of the necessity, which means I'm creditors for support, so grocery store, cards, rent, some of those things, I can potentially pierce an irrevocable trust. Your child support and alimony are not deemed to be, that you can't pierce it, because if you set it up right. Now there's so many things you have to do right here. So I haven't gone through it, but you have to have a Nevada trustee. The Nevada trustee has to do the taxes here. And so there's a whole aspect of what you have to do. And then you pretty much, by doing that, you have a Nevada trust holding your Nevada property. So it's not subject to Nevada. Nevada only has federal tax, not state income tax, where Washington just got rid of that almost. So what you do is you're like, okay, that may make sense. There are laws in different states, California and New York have them. If you're a New York or California resident and you do this sort of a little bit wrong, they're going to say you're still taxed. You can still tax that trust. So you have to be measured in how you do it. So when I set these up, usually I want to have a Nevada LLC holding the assets, so you have that protection, and then you have this irrevocable trust owning that LLC, so you have another protection. And it's you're segregating some assets. So you do these on assets that you know you're not going to take a whole lot of money out all the time. You're just going to let this grow. Maybe you'll use it to do other investments and things like that. But it's separated. So even if you get sued after 2 years and making sure you do a few other things, in Nevada, creditors can't go after you. Now, the question is, because this is a Nevada one or an Alaska one or South Dakota and Oklahoma, they're in different states now. But if you go drive in California and you get in a bad wreck, California doesn't recognize these. So the general rule was for hundreds of years, I cannot set up a trust for my own benefit and not be liable for my own debts. You can't do that because there was an aspect where they merge. So if it was for the benefit of you and your kids, there was a doctrine of merger, and so you couldn't do it. It's like, I'm a creditor, it's just like a regular revocable trust. I can do it. So that's the common law in the United States and most states. Now we have, I don't know, there's a lot more now, 10, 12, something like that now have. So asset protection trusts are sort of like how LLCs were back in the 80s, where was it Wisconsin or
was it Wyoming?
Wyoming?
Yeah.
So they start in Minnesota, but they started these. It slowly went to others, and now every state has it. I don't know if that's going to happen here because some people say that's just not right. It's your money. All you can do is put it away and give it to someone else to manage it, but you're still the beneficiary. So there's some moral issues going on, but Nevada's had this since 1999. It's pretty well established. The exception is if you go into bankruptcy. There's a 10-year look-back period. So if you set this up, and 5 years later you go into bankruptcy, either voluntarily or involuntarily, they're going to be able to pierce that because they have a 10-year look-back on it. So they're not as palatable for some people who know that they may end up having those issues. But I don't. The other option is offshore trusts. I don't really talk about those, but you're really giving you have to trust that offshore trustee that they're really going to follow and do what you want, and that has this whole other set of problems. So what I want to talk about with the professionals in the room, and most of you are, and you want to talk to people about them, is like, spot the exposure, start telling them, you may not be able to get them to do anything, but then start thinking about it. And then if you can connect them and we can set up a good plan for them and they understand that they're protecting themselves, you're building value with them. And so that helps both of us, all of us in this room. So now here's my disclosure. This presentation is for educational purposes only and does not constitute legal, tax, insurance, or financial advice. By the way, I'm not licensed as an insurance agent, so I can't. No attorney-client relationship is created by attending this presentation or receiving these materials. Asset protection strategies must be tailored to your individual circumstances and put in place before any claim or creditor arises. Laws, coverage terms, and dollar figures vary by state and carrier and change over time. All examples shown are just illustrative, and none of them is real examples. I just try to give you hypotheticals. These strategies must never be used to hinder, delay, or defraud known or existing creditors. That is what's called that fraudulent conveyance law. And it's recommended you talk to a licensed attorney, a licensed insurance professional, and a tax advisor to do that. I can do some of that tax advising, but I always like to work with the CPA because they're the ones who, so in my opinion, what happens for me is the CPA is usually the one who knows when something bad's happening because they are in front of that client every year. So hopefully we can build that team so they know, hey, there's something else here. And so you always want to make sure you have a good account who's willing to talk with the other members of the team. Now, I can also tell you, working for revocable trust sometimes make a good plan because if you have a basic estate plan in there, you have that foundation, and then we can figure out which goes in your revocable trust, whether you need a irrevocable trust. So if you have one property, I would not say you get an asset protection trust. Now, there are attorneys who are going to tell me I'm stupid. I can create and charge them money for an asset protection trust. I think develop your wealth a little bit, use more insurance, try to protect yourself that way. But as you grow, you're definitely going to need some more advanced planning.
I want to understand more about the Nevada Asset Protection
Sure.
Trust. Are you saying that goes on the, when you said it was layer 3, is it
So
top?
imagine this is a Nevada Asset Protection Trust. This is the property, and this is the LLC. So what you do is you have put the property in an LLC. Then we create a Nevada Asset Protection Trust, and that Nevada Asset Protection Trust owns the Nevada LLCs. You don't own it anymore.
I see.
After 2 years, assuming you meet certain requirements that are a little more in depth, Nevada creditors cannot go after that anymore unless there's a 6-month discovery rule if they should or should not have known.
And then
So
you can put multiple LLCs in that.
Yeah, you can
trust.
put a whole bunch of things in there.
Okay.
And it's just like you owning different things. So you have that different layer of protection, and they have to go through, so they have to go through this and then this to get to you and your other
You don't own
assets.
anything the trust
Right.
owns at all.
So no, don't make it own everything. That's the other problem. I
okay.
just talked about asset protection. I had so many clients say, well, I'm going to put everything into Nevada asset protection. Fraudulent conveyances, if you make yourself insolvent, everything comes back.
Wow.
You can't make yourself insolvent. So you always have to have enough assets to pay your known liabilities. And if you don't have enough assets to pay your known liabilities, you should not be setting up a Nevada Asset Protection Trust. There are other ways. We may have someone else set up a trust for you and other things, but those are different types of more complex things that could take a whole day to talk about.
I'm
Awesome.
not really ready for that.
Awesome.
was
Great
great.
job. Thank you so
That was
much.
great.